This is an update on California's CCPA or CPRA laws.
Why should I bother about the CCPA? If you're doing business with any California residents, there are non-compliance penalties. We're starting to see clients be affected by this. One of the other questions we get asked all the time is, does server-side tracking help? No, in that, can you stack the odds in your favor? A little bit. Is Google Analytics compliant by default? No, it's not. So there are a number of steps that you need to take to make GA CCPA compliant. Will it affect your site? Yes, it will. You will have reduced tracking data, and you'll probably see a little bit of a reduction in sales. We're going to be missing data. It's as simple as that.
You're spending real money to drive traffic to your site, but the truth is 98% of that traffic leaves without ever giving you an email. Meta knows who they are, but you don't unless you use Instant. Instant helps brands identify anonymous visitors so you can send more abandonment emails, build stronger retargeting audiences, and actually recover that lost revenue. Brands like Fate the Label saw a 4.5x boost in their abandonment flows. Masco increased Shopify revenue by over 15%. Third Love, Toys R Us, and the Oodie, these are all massive stores that use Instant to see an average ROI lift of 11.2x. They'll even guarantee you a 4x ROI or your money back. It only takes 15 minutes to set up and you'll start seeing results fast. If you're serious about getting more out of the traffic you're already paying for, now's the time to fix it. Get 50% off your first month at instant.one/DTC. That's instant.one/DTC. It's all killer, no filler, and today we are diving in with Pilothouse's technical manager returning to the podcast, Mr. Richard. Welcome to D2C. How you doing?
Thanks, Eric. Yeah, I'm doing well. I can't complain.
Dougie suggested we bring you on to discuss something that's affecting a lot of people in the industry, affecting Pilothouse clients already, and this is an update on California's CCPA or CPRA laws. And you say you've sort of prepared a bit of a presentation here. So if you want to kind of take it over, I guess you have slides. You can do a screen share. People listening can either watch on Spotify or YouTube or just listen to Richard's dulcet tones. But yeah, I'll turn it over to you. And then can I ask questions as we go? Or?
Yeah, totally. Yeah, totally. And, while this is an area that I know quite a bit about, in preparing the presentation, I wanted to make sure that I'm not putting anybody completely in the wrong direction. And I think it is worth saying right at the start here, Eric, I'm not a lawyer. If you've got any concerns about any of this at all, please get proper legal representation and advice.
All right. Disclaimer.
So I thought I'd start off by having a look at what is the CCPA, and you mentioned there some other acronyms, the CPRA. So the CCPA 2020 is the California Consumer Privacy Act. This gave people, residents of California, the right to know what personal information is collected about them, why it's being collected, and any third parties with whom their data is being shared. It also allowed them at that time to request deletion of their data and opt out of the sale of their personal information. So that was kind of step one in 2020. And then in 2023, they enacted the California Privacy Rights Act, the CPRA, and that gave additional protections, including the right to correct inaccurate information and the creation of the California Privacy Protection Agency, which is also CPRA, but not the act, it's the agency, to enforce the law. So they don't operate, in lieu of each other, that they work together. It's the CCPA and then the CPRA sort of sits on top of that. So then I thought, okay, so let's get people's attention here. Why should I bother about the CCPA? And the reason is because if you're doing business with any California residents, then there are non-compliance penalties, which is, as you alluded to at the top of the podcast, Eric, it's we're starting to see clients be affected by this. So there's a number of different ways that you can get penalized. So there's, first of all, there's civil penalties. So that's if you have an unintentional violation, an intentional violation potentially, and then if you have repeated violations. So this is where people can basically go to the law, to the Attorney General, I guess it ends up at, and they can impose various penalties. So it's up to $2,500 for an unintentional per violation, 7,500 if it's intentional. And then if they start racking up, then they'll keep ramping it up if you have multiple violations. So those are civil lawsuits.
And that could be per email, per person, per email address.
Yes.
So that can
per visit. If there's data flying off to Facebook and Google and wherever else, then every one of those can be a violation. So that's the first one. The second one are these consumer lawsuits, the private right of action. So this is where if there's a data breach, so if a CCPA violation results in a data breach due to inadequate security, consumers can sue for damages. Now, the limit of that is up to $750 per person per incident, or the actual damages, whichever is greater. So if, I don't know, something happens and some data gets leaked and it gets used and they lose more than $750, then they're entitled to get $1,000 or $2,000 or $5,000, whatever happened as a result of the data breach. And then it is possible for class action lawsuits to be filed. So that really could potentially expose businesses to a lot of liability. So that's the second one. Then there's injunctions and other remedies. So an injunction, a court can issue an injunction, just say, no, you got to stop until you get compliant. And this other one, declaratory relief to clarify legal obligations. So, I mean, these things really can ramp up. And then finally, the agency, which came out of the CCPRA Act in 2023. So this is where they can basically, they've got enhanced enforcement powers, and they eliminated the 30-day cure period. So there used to be you've got 30 days to fix it and then you're okay. But they eliminated that, but that still might be granted at the discretion of the agency. And they can actually, if they get involved, they can actually impose higher fines and increase enforcement. So there's 4 different ways there that can get hammered.
It's got teeth. Stops just short of putting you in the public stocks and have people throw tomatoes at you.
Pretty much.
And it stacks. It sounds like it could really stack as well.
Absolutely.
Across, it's not mutually exclusive.
No. So, it's some pretty significant stuff. And we are starting to see some of our clients get sued under the private right of action and some of these civil penalties as well. So definitely something people want to pay attention to. In California, the CCPA does have a threshold, and it's a pretty high threshold. So if your business meets any of the following, if you're doing business in California, so you can be located anywhere at all, but if you're doing business in California, if you've got a gross annual revenue of over $25 million US. Second one is if you buy, sell, or share the personal information of 100,000 or more California residents or households, or if you derive 50% or more of your annual revenue from selling California residents' personal information. Now, their definition of, I'm not sure where I've put it, but their definition of selling is pretty broad. If you're getting any kind of business benefit, then that's considered selling. So it's not me, selling you, a load of email addresses necessarily. That obviously would be part of it. But in sharing and giving information to Google Analytics or the Facebook Pixel or TikTok or wherever.
It could also be interpreted as buying, I think, for a lot of our listeners as well, because you're buying, the sales through Meta in a way, which are giving you all these email addresses. I don't know.
Yeah, I mean,
but you're saying this applies, even though it doesn't say this applies to e-commerce sellers.
Yeah. Yes, absolutely. It's not just people who are in the business of
data brokers.
Yeah, data brokers. Yeah, absolutely. It's not. Yeah. It's not just those people. This is e-commerce businesses. You're going to be part of that.
Okay, so there's a threshold, but so those listening who are under $25 million can take a small sigh of relief. But probably you never know when they're going to march this up and have it apply to more people. So it probably behooves you to pay attention and get right as much as you can.
Absolutely. And interestingly, I'll come to it in a second. There's different legislation for different states. So this obviously is California's Privacy Act, but there are other Privacy Act, and I'll just touch on one or two of those in a minute, just to kind of clarify what some of the other ones have done, but I'm not going to go through all of the states that have enacted Privacy Act. It really is obviously up to the businesses to do their homework and get their lawyers involved and figure out kind of what you need to do. But ultimately, it's all heading that direction. And of course, if anybody's doing business in Europe and the GDPR applies to them, then that's even more onerous than the CCPA. So it's all heading that direction. So I think ultimately, even though it's only it's not all of the US states right now, I think it's going to get there. And so I think everybody's going to have to stick adhere to it. I mentioned before about the civil suits. So people can only sue under the CCPA if personal information is stolen. Let's say stolen. It gets lost. We'll generously say, and it has to be first name or initial and last name in combination with any of the following. So the social security number, driver's license number, tax ID, passport number, military ID, or some other unique government issued identification, your financial account number, credit card number, debit card number, and any required security codes, PINs, etc., medical or health insurance, or your fingerprint, retina, iris image, whatever, some other unique biometric data that could identify a particular person, not including photographs, unless they're being used or stored for facial recognition purposes. So those are the only times that people can actually sue under the CCPA. So even if you're not compliant, then the CCPA, the agency, or one of the other routes, you could get in trouble for that. But individual people can't sue you just because you've got a Facebook pixel on your site and you didn't tell somebody about it.
But your credit card number is still happening in this transaction, so you still technically could be sued if you're passing loose with the credit card number. Only
if that, if they get hacked, if the company gets hacked and that credit card information gets out into the wild, then that's the problem here. That's where the condition would apply. So not just for storing it. If you're storing it and you didn't tell them, as long as you don't lose it or it gets hacked, then you can't get sued.
Okay.
So just to continue that just a little bit, the PI, the personal information, must have been stolen in non-encrypted and non-redacted form. So if it's encrypted, then that's fine. I'm going to say fine. I mean, I don't mean obviously that data getting stolen is fine. It's not. But just in the terms of what we're talking about here, it has to be non-encrypted or and non-redacted. It must have been stolen in a data breach as a result of the business's failure to maintain reasonable security procedures and practices. They can sue for the amount of the monetary damages suffered or statutory damages up to $750 per incident, which isn't too bad. Before suing, you must give the business written notice of which CCPA sections it violated and allow 30 days for them to respond. And if the business is able to actually cure or fix the violation and give you its written statement that it has done so, you can't sue the business unless it continues to violate contrary to its statement. So fair bit of protection there for businesses that are doing the right thing, trying to do the right thing. You'd have to be pretty negligent, I think, to end up being sued under the CCPA.
Yeah, you'd have to ignore a lot of warning signs.
You certainly would. So one of the biggest questions we get asked is, does the CCPA apply to non-California businesses? And yes, it does. So if you're doing business with California residents, it doesn't matter where you're located. That's the criteria. It's just getting personal information from California residents. So absolutely, it applies to non-CA businesses. And are there any other states doing privacy stuff? Absolutely. Colorado, Connecticut, Delaware, Florida, Indiana, Iowa, Montana, New Hampshire, New Jersey, Oregon, Tennessee, Texas, Utah, and Virginia are the ones currently. And there's 2 or 3 others in the process. So these ones have all enacted some kind of privacy act. There's 2 or 3 others who are going through legislation to enact privacy acts. And we're just looking very specifically at the California Act here today, but each one of them are slightly different. And just to give you a flavor of that, the Virginia Consumer Data Protection Act, the VCDPA. Their threshold is slightly different from California. So they've got two thresholds, either one if you meet. So if your controller processing the personal data of at least 100,000 Virginia located consumers during a calendar year, or a controller process the personal data of at least 25,000 Virginia customers, and you derive over 50% of its revenue from the sale of personal data. So that really is aimed at the data folks. But you'd need to have a pretty big e-com business to be having at least 100,000 Virginia customers, I would imagine. So, but those are there's their thresholds. And the other one I pulled out was the Colorado Privacy Act, the CPA. They were similar to Virginia, 100,000 or more Colorado residents, and derive revenue or receive discounts from the sale of 25,000 or more Colorado residents, which was slightly different. They didn't have the 50% of the gross revenue. They just said any revenue or discounts on goods and services from the sale of personal data of 25,000 or more. So that was just a couple of other ones that I pulled out just to give people an example of how other states are doing it. Again, get your lawyers involved. Go and have a look at what each of these states are doing. I mean, it would be rare for any one of our e-com clients to not be doing business in pretty much all of the US. So, I think this is going to apply to almost all of them. And of course, once you start enacting it to be compliant with California, are you going to show somebody in Colorado a different version of your website, and somebody in a non-Data Protection Act state, something else again? I don't think so. You're going to want to just employ another, an across the board solution. But I thought it was worth mentioning that anyway. So, how do we make a store CCPA compliant? So there's 3 steps. So the first thing you've got to do is you've got to add a privacy that complies with the right to know, and this is where most of them are going to be very similar in terms of what needs to be in this privacy policy. But it's basically saying, here's what we do with your data. If you say yes to the analytics section, then we use Google Analytics or whatever it might be, and that's how we use your data in that instance. And we use a Facebook pixel, and here's how that's used. So you've got to detail how their data is being used. You've got to allow customers access to their data. So they've got to be able to see what it is that they've kind of signed up to or not. And you've got to allow customers to opt out of the sale. And I say the sale is very much anything that's business transactional, analytics, pixels, all that sort of stuff. So they've got to be able to say, yeah, no, thanks, I don't want to be in this. So those are the 3 steps to actually making a store, an e-commerce store, CCPA compliant.
How do you let your customers know their data? Is that like in their customer profile there you needed to add a tab that's like data, and it's like, here's the data we have on you? Yes.
So I was going to come to that because, essentially you somehow need to say, okay, here's your data, Eric or Richard or whoever it might be. So the best way, certainly if you've got a Shopify store, would be to use one of the compliance extensions. And ConsentMo and Pandectis are the 2 best well-known on Shopify. There's another one which kind of works with Shopify as well as a number of other platforms called SecurePrivacy. There are a few others, but certainly for Shopify, ConsentMo and Pandectis are the ones I've seen the most of. And what these compliance extensions do is that they do everything. So literally, they'll do the banner that comes up or whatever it is, and says, hey, we use your data. Are you in? Are you out? Or here's what options do you want to have a look at? They also then will allow customers to access their data via the extension, and then they can also opt out at any point. So the full compliance extensions like ConsentMo, Penalties, SecurePrivacy, they handle it all. There are other banner kind of extensions, but they're not doing it all. The banner ones will just come up and say, hey, we use third-party cookies. Do you consent for functional use, essential use, functional use, analytics, and then the 4th one's usually targeting advertising. But that's all that they do then. So if to be compliant, you've got to give people access to the data. The banner extensions don't do that. And if somebody wants to opt out, then they also don't do that either, other than going back again. and the software not realizing that they've already opted in, and then they're giving them the opportunity to opt out, which is obviously problematic. So be careful if you're trying to be fully compliant. Look at one of the full compliance extensions like ConsentMo, Pandectis, or something like SecurePrivacy. Now, one of the other questions we get asked all the time is, does server-side tracking help? No, in that server-side tracking doesn't bypass your need to comply. You've still got to comply. The server-side tracking platforms like Elevar, and I've talked about Elevar on this podcast in the past, and they do work with compliance apps extensions. So Elevar, for example, they work with Pandectis, OneTrust, ConsentMo, CookieBot, PyEye, UserCentrics, TrueVault. I think that's an exhaustive list as we speak. So if you've got one of these other platforms, then something like Elevar will work with those. Now, what it doesn't do, it's bypass. Just because your server-side tracking doesn't mean, okay, I'll track them using first party. It's totally fine. I'm not using cookies. No, you can't do that. If somebody says I'm out whenever they go to the banner, you can't track them. You can't use their data. No ifs, no buts. If you're being compliant, you can't track them. You're not allowed to track them.
That's so tough. But if they see the ad in the wild, they don't really have a way of knowing whether they were retargeted or just targeted.
No, but yeah, when they come to your site, my site, yeah, they're entitled to find that out if you're being compliant. So it's a real pain, and I have to say, I'm sort of going off script a little bit here. I think it's way overkill. I mean, these websites, a lot of them are providing services, they're providing products, that people want. They've got to make money in, and I think it's gone too far the way of,
or too broad. The brush has been too broad. If we're talking about data brokers, spammers,
100%,
things like that,
they shouldn't.
Yeah, but they should have had some more provisions in this to shield legitimate businesses who are collecting data at large scale due to them wanting to, they're wanting the products that they're selling.
Exactly. And if you're online and you want to buy the product or find out some information, then that's fine. I mean, did people expect to get a newspaper for free before the internet existed? No, of course not. You expected to pay for the newspaper because there was a lot of stuff went on behind it. Why is this any different? And this is just my personal opinion that you're hearing here, but
I asked ChatGPT for an outline of the things that e-commerce advertisers would need to know. The first one is that you're liable even if you're not based in California. This is just if you make any sales there, which you mentioned. I think that's great. The thing that I mentioned here is that performance marketing tools often can trigger compliance requirements, just because when you're going with pixels across all these different platforms, relying on a lot of growth across Meta, TikTok, Klaviyo, you're sort of just like inherently in these woods the way that it's written.
Absolutely. 100% you are. 100% you are. And to say, I think this is where it's gone too far, because if it's all, anonymized, and it's grouped up, so that any particular audience has to be at least, 100 people, 1,000 people, whatever, then you can't individually identify somebody to target them. They're just part of buckets. And would I rather get ads that I'm interested in? Absolutely. I don't want ads for stuff that I'm not interested in. So it's, in my opinion, and I say this is my personal opinion, I think this is all a little bit overkill. But
it's happening.
It's happening.
Legal enforcement is happening. It's happening to clients. What, like, we obviously can't give too much information there, but can you paint that picture a little bit about what went wrong there?
I don't know the details, so I'll maybe try and find out. Maybe we can do a little follow up or something. But yeah, they're getting sued by, I think it's individuals. So for that to happen, there has to have been a data breach. They have to have their data had to come out from that company into the wild, and I'm not sure that that's actually what happened. So it could be maybe somebody just having a bit of a phishing exercise.
And that's the big problem, is whenever you get these broad rules, you get all the people in there. I forget what their term is for that kind of law.
Yes,
but people that will just exploit this kind of situation to make money.
100%. And the US is is particularly litigious and
frivolous. Yeah, exactly.
So it feels like it's a bit of a field day out there. So yeah, I'll actually give you some data. I've just got a couple more slides here, just on kind of the impact of that implementing, kind of full compliance kind of has. Very quickly, I just want to say that can you stack the odds in your favor? A little bit. If you're going after GDPR, then no, it's totally opt in. So all of those boxes have to be cleared. Nothing has to be, can be pre-ticked. People have to tick every one of those boxes to opt in to, let's say, essential, functional, targeting, etc., etc. With the CCPA, so far, at least, it can be opt out. So you can have all of those boxes ticked and just say, yeah, I consent to all. So it's an opt out model currently in the CCPA. So that's something, at least, you're not making people, check 4 boxes before they can actually get in. They can just click one and off they go. So that's something that you can do. Is Google Analytics compliant by default? No, it's not. Unfortunately. So there are a number of steps that you need to take to make GA CCPA compliant. Again, it's the policy. Make sure you're not storing things like user IDs in GA. Enable IP anonymization. That's just a very quick update with the code. You disable data sharing. Now that's a little bit of a pain because that's all your remarketing stuff. You add your cookie consent banner. And then if somebody wants access to their data, there is a way actually within GA that you can do that. But that's literally just GA. I'm not talking about Google Ads. I'm not talking about Facebook, TikTok, anything else. That's just GA there. Canada, just because we're Canadian, there is a thing called PIPTA, which is very similar to CCPA, and pretty much the rules and regulations are the same, except there are no thresholds. It does apply to all e-com businesses. It's not really being enforced in Canada. However, the CCPA has been talked about for quite some time. It would be very similar to the GDPR, so literally it would be much more strict. It hasn't gone through yet, but they're talking about it in Canada. So officially, to be compliant in Canada, you are supposed to have consent banners and all that good stuff like the CCPA.
And so you've said consent banners a few times. So consent banners are literally just they're horizontal things that go across your site, or like where are the banners specifically? They're in the checkout process?
No, as soon as you come onto the site, because if you don't ask for people for consent as soon as they hit your site, then you're not.
It's too late. Yeah.
So as soon as they hit your site, I'm sure you've come across them. They're usually sort of banners at the bottom, but you can actually, I think, ConsentMo and Pandectis, I think you can kind of say, well, actually, could you do it like a pop-up, or could you do it like, I think there's 2 or 3 ways that you can do it on these compliance platforms. But most people will know from the bottom, and it says, hey, do you agree type thing, and there's 3 or 4 boxes that you can check. Just to finish off, Eric, I thought how can all this affect your e-commerce site? Say you want to be above the law, you want to be compliant. What impact might this have? Will it affect your site? Yes, it will. You will have reduced tracking data, and you'll probably see a little bit of a reduction in sales. Although I think when everybody becomes compliant, then it'll have less of an impact because people will just be used to it, and it'll just be one of the standard things that happens every time you go to a website. If you haven't already given your compliance and the cookie's not there, then it'll say, are you compliant? Or sorry, are you in? Or are you out? And I think people will eventually get used to that. Will it do away with the missing data? No. I mean, we're going to be missing data. It's as simple as that. But GA and various platforms have been modeling for years, so we'll just have to get better at modeling. And just finally, to finish, I wanted to give a very recent client example. One of those clients that was getting potentially sued. They went ahead and implemented one of the compliance platforms. And what they saw was a 28% reduction in conversions coming through on Google Ads. They saw a 58% reduction in overall sessions coming through on Google Analytics. However, they only saw a 4% reduction in actual purchases. So lots of data missing, but the overall impact on their business was, nobody wants to see your business go down, but it wasn't as big as the missing data might have.
It's a great shout.
Indicated. So I don't think that's atypical. I think that's going to be similar to whatever anybody's going to see if they're implementing some of these consent platforms.
What percentage of customers are going to manage their data, I wonder, right? Like,
I would imagine, I don't have that in hand, but I'd imagine it's very small. I could care less about,
yeah,
about
yeah,
my data. In fact, typically when I go onto one of those sites, I go functional yes, targeting no, and analytics yes, and I'll, because I'm obviously part of the industry and I know what it's like if you're missing analytics data and stuff. So,
oh, that's nice of you.
yeah,
That's nice.
I'm a decent sort,
That's good.
but that's typically what I'll do. So,
Yeah.
yeah.
So get on it. Get compliant out there, folks.
Yeah, compliant
Even
out
if you're
there,
under that
'cause
25 million threshold.
yeah, because you could really end up in trouble and and have no business and and be sued for millions. So we don't want that to happen to anybody. And it is fairly straightforward. The downside is the lack of data, but I think that's coming anyway. Whether it's via one of these privacy acts or whatever, it's going to happen. So we'll all just be top of funnel advertising in due course, Eric. And
yeah,
there will be no remarketing. There will be no bottom
just
of funnel.
newsletter advertising.
It'll just be top of funnel. Pick your audience.
Everything is top of funnel.
Yeah.
I like that. Like the industry needed another big hurdle to get over. And help me clear. So I understand these tools and the banner that'll pop up for all new people coming on. How do you get compliant with all the data you may be storing for your existing customers and customer base?
So you've basically got to get it all in now. Some of those compliance platforms, they'll import what they can. You've just got to try and kind of catch up with whatever you can. And if you are storing any kind of personally identifiable information, PII, get it into one of those compliance platforms or get rid of it, because if that goes out into the wild, that's really when you get into big trouble. So if you've got any kind of social security numbers, credit card numbers, bank account numbers, anything like that at all.
Geolocation was one that kind of surprised me in your presentation there, just because I feel like every ESP keeps track of people's IP addresses or their approximate geolocation anyway.
Yeah, and an IP address is considered PII.
Yeah.
And a MAC address would be a PII, a user ID if you're, say you're using it in GA or something to track users, that's PII, and that's one of the things you'd have to get rid of for GA to be compliant. So. Yeah.
And so you need them if they accept it now. If I've been a customer for a long time at a brand, but I go to their web and they haven't implemented any of this stuff, and then one day they implement it, and I go on there and I say accept all. Does it like retroactively make it okay? You're not a lawyer, I know.
That's a good question, and I'm not a lawyer. I would imagine yes, it does. Because it's you. Whether you gave your info a year ago or today. It's your data. No, it never excuses a breach. If your PII gets out into the wild because of a breach, that never gets that's never excused. But if you're then unhappy because Facebook show you an ad about something you visited on their site, then no, you can't do anything. You wouldn't be able to go back. I guess if you could prove that you're being targeted before you gave your consent.
Totally.
But I'm not seeing many of those kind of lawsuits. Certainly not in Canada yet, anyway. So
nice. Well, another podcast of hyper relevant, necessary information. Are there any other further points you wanted to highlight here?
No, I don't think so. I think everybody's going to have to do this at some point. Obviously, the bigger businesses, 25 mil in California, particularly. But yeah, I think just get on it and get it done, because you just don't want anything to happen to your business. But the downside is the lack of data, and we're always complaining about the lack of data before this. This is only going to get worse. But maybe the sooner you embrace it, the sooner you'll find ways and means of overcoming it. So
I have a sci-fi hunch that I talk about on this podcast all the time, that we're going to get to more of an era where we have our data profiles that are a bigger part of like who we are and what we recognize. We'll have to, UBI in the future will be tied to these digital profiles, and we'll have AIs that like help manage all of our personal data. So we won't have, because we don't really care, about so much of them, but we'll have AIs that we give settings to, and then it will allow, and we'll find more and more ways where we're intermediating in the world between our AIs. And we'll actually monetize our data better. Like everyone will be an influencer, like literally when that system kind of comes into place.
Absolutely. And that makes sense if I'm always happy to be, everything except, targeting or whatever it is, or if I'm totally happy to be everything, then why do I need to just keep doing that on every site that I go to? If AI knows me and then I go to any site, then it just preemptively just goes, yeah, Richard, he's good to go on all of this, and whatever it might be. So I hope that's where it ends up.
Yeah. Well, if you want to talk to a semi-pro about this, you should email Richard at Pilothouse. And again, he's not a lawyer, but he's researched it probably more than most. But anyways, have a look at it for your organization. Make sure you're compliant. Maybe I'll put the notes from this presentation in the show notes, so that if anyone wants to go deep on the options kind of laid out there, we'll make that available for everyone. Thanks for coming on today, Richard. This was good.
You're very welcome. Good to see you, Eric.
Thanks for listening to today's episode. If you're not getting the D2C newsletter, you can subscribe for free at directtoconsumer.co. And if you want to learn more about Pilothouse's all-killer, no-filler services, take off to pilothouse.co. I'm Eric Dyck, and this has been the D2C Podcast. We'll see you next time.